My name again is Craig Riffle. I have Jessica with me today, Ryan's with me today, and Alana's with me today. And we'd like to thank Medic for having us today. My wife swears that I take every opportunity I can to talk, so you've given me that opportunity today. Now, she did tell me when I left the house today, get it out of your system, so when you come back, you don't have to listen to me. But anyway, what we're going to do today is we're going to talk about power of attorneys. And we're going to work through those. And this is not a lecture or a class. This is, let's talk about it. I want to get you the information that would be helpful to you. We will talk about specifically about the Texas requirements for a power of attorney, and then we'll add some Oklahoma flavor to that. So let's get started. The first thing I have to do before I do anything is I have to know why. In other words, lawyer, you're telling me I need a power of attorney. Why do I need a power of attorney? Why am I doing this? And I think a lot of times if people understand that, they have a better understanding of what they're doing. The reason for a power of attorney is, like I said, I'm married. I have 2 adult children. Let's say that I'm incapacitated. I'm not deceased, but I can't make decisions for myself. The question becomes, how does my wife do that for me? She can't do that for me just because we're married. Some people think that, well, if you're married, then your spouse can do that. That's not the way it works. And that's the same. And if I have any differences between, I'm tailoring my discussion to Texas, but if I have any differences to that with Oklahoma, I'll let you know. But both states, Oklahoma and Texas, just because you're married, you can't do that. Or my adult children can't act for me just because I'm married. Now, what do I mean by that? What if there's something that needs to be signed on my behalf? Well, that's what we're talking about. I can't do that. Maybe it's a physical problem, maybe it's a mental problem, whatever it may be, but I can't do that. Sometimes also regarding health. Now, what we're talking about today is specific to financial. But if I can't do that, they have to have the authority to do it for me. Well, there's one of 2 alternatives. Either they can have a power of attorney, which is what we're going to talk about today, or they're going to have to be my court-appointed guardian. Now, you probably have heard a lot, and it's a little different in Texas than it is Oklahoma. Texas system for probate's a little easier than what it is in Oklahoma. It still can be cumbersome, but guardianships are much worse. I'll give you an example. If I don't have a power of attorney, then what has to happen is my wife would have to petition the court to be my court-appointed guardian. So she's basically suing me to have me declared incapacitated. The court will appoint an attorney for me to represent my interest. If she's successful in being appointed my guardian, then what happens is she has to file an inventory of my assets, a plan for the care of my person, my body, me, myself, and a plan for the care of my assets. And every year that I'm alive, she has to update those and provide an accounting. And that's why it can be very time-consuming and expensive. Well, the alternative to that, someone somewhere said, is there a better way? And that's the advent of the power of attorney. All states have them. There's a uniform act that they're very similar, but there are some subtle differences. And so we'll talk through that. So that's why we're talking about a power of attorney. In Texas, here's the Texas code for power of attorney. And Greg, we're talking, what I said earlier, we're talking about Texas. We're going to add some flavor for Oklahoma, but they're from Texas, and so we're going to, but it's going to be very similar between those 2 states. There are states that's a lot more dramatic different. It starts off by talking about some important notices, and the notices really are and these again are required by statute. They're to give you some idea about how the power of attorney works, and so that's section 1. And it's important here to note, they also put in here that this power of attorney is going to continue until you die, or you revoke it, or you resign, or a guardian's appointed. Okay, so let's talk about these. Some people think, they'll come in my office, they'll say, well, mom's died, but I've got her power of attorney so I can act for her. In every state, a power of attorney ceases to be effective when the person dies. It's only so that someone can act for you while you're alive. And so Texas has made that clear here. Obviously, the agent can resign. Why do we have number 3 here if a guardian's appointed? Well, there are some instances where maybe the power of attorney is not good enough. I said they're basically alternatives to each other. But a good example is, let's say that power of attorneys have been given out and there's a dispute among kids or whatever it may be, well, in that situation, the court may feel like they need to appoint a guardian. And so if you have a power of attorney, it isn't absolutely sure that you'll never have a guardianship, but it's really close that you won't. When we approach this problem, I approach it from the standpoint of let's do the least intrusive and the least costly. So if you're going to an attorney, I know you said your grandson or son? Grandson. Okay. I know your grandson will take care of you, but most people, when they're facing of going to an attorney that they're paying for, it's a lot less expensive to do a power of attorney than it is to go through a guardianship. And so that's why we do that. Let's go to section 2. So what you have to do, in this case, we've plugged in in the highlighted areas is some sample information. Now this is all fictitious. We've just made it up. But in this, and this information originally comes from our Oklahoma power of attorney. This is in Texas, so typically this would say state of Texas. It would be an address in Texas. But the gist of the power of attorney is that this person, John, has appointed Susan, his spouse, and there's an address and phone number. Now, most states, when we first were doing power of attorney years ago, you just had to identify the person you're appointing by name. Now, most states, including Texas, requires that person to be identified by name, relationship, address at the time, and phone number. One of the questions people ask me, well, what happens if Susan moves? And sometimes it's a child. What happens if my child moves? Do I have to update my power of attorney? The answer is no. It's just for identification purposes at the time the power of attorney is signed. Now, what we have in this case, John has appointed Susan to act for him under section 2. And if we go to section 3, if you notice, it's successor agents. So he said, if Susan doesn't act, then I want Emily to act, daughter. And that's her identification. And then if she can't act, then I want Angela. Now let's talk about appointing the power of attorney. You can do it. People ask me from time to time, do I appoint one, then the other, or do I appoint them together? It's your power of attorney, and you can do it however you want to do it. So let's go back to section 2. He could have said, I want to appoint Susan, Emily, and Angela all to serve together. You can make any combination of that you want. What I typically see that's very common in a situation where they're married is usually it's spouse first. But then many times when it gets to kids, we have a variety of different things. Maybe they appoint, how many kids do we have in this one? Is it okay, so we have Emily, Angela, and what's the third child? David. Okay, so it's very common to see them appoint the spouse first, but then to come in and say, well, I want all 3 kids to serve together. Or I want them to serve in consecutive order. So the first question your grandson's going to have for you is, number 1, who serves first? And if that person can't serve for some reason, do you want an alternate? And who's that alternate? If there are multiple people like this, then you have a choice. You can name them consecutively like John has. John's named Emily, Angela, and then David. Or you can name them together. I want them all 3 to serve together. Now, if you choose the second, the next question the attorney's going to have is, how do you want them to act? Meaning, we have 3 people acting, right, in this case. Can any one of them act independent of the other? Or do they have to act by majority vote? Or does it require unanimous consent? There's no magic answer to that. It's whatever you like. It's whatever you prefer. You can do any number of combinations. You could say, I want Susan to act, and if Susan can't act, I want Emily and Angela to act. And then if one of them can't act, I want David to replace that one. It's any combination you want. The only thing you have to keep in mind, if you name more than one, we have to give direction as to how they're going to act. Because remember, how's the power of attorney used? Well, what happens, my example, for instance, I sign the power of attorney for my wife to act for me. If she needs to use that, let's say she needs to use that at a bank. She's going to go to the bank and give them a copy of the power of attorney. She needs them to take that. She needs them to accept that, right? So let's say she can't act, and I've named both my kids to act. They go to the bank, and let's say the power of attorney just says both kids, in my case it's Colburn and Camber, both kids can act for me, and they go present their power of attorney, but the power of attorney doesn't tell them, can one of them act alone, or do they both have to sign? So what's going to happen is the bank's going to be cautious about that and require both signatures. And so we always want to designate how they're going to act. So in this case, what we've done is we've appointed wife Susan, then we've appointed in successive order. We've appointed Emily, then Angela, and then David. So Emily serves. If Emily can't, then Angela, and then David. All right, let's go to the next section. Section 4 is something that's more and more common. Years ago, what would happen, and when I say years ago, I mean prior to about 5 years ago, what would happen is we could just say the power of attorney can act for you in all capacities. That didn't matter whether you're in Texas and Oklahoma. Texas changed theirs first. Oklahoma followed a little later. Oklahoma did theirs in 2022. But what it says now is you have to go through an initial what powers you want them to have. This is really growing from the, a lot of this push is from the Bankers Association. They like, both in all states, they like to see specifically, do they have the authority to do that? And so if you'll scroll down just a little further, so scroll up, there's this last, go down just a little bit. There's this last choice, right? Pull this down. There's this last choice right here. In other words, you can go through and say, okay, I want them to have real property, they can act on behalf of me regarding my real property. Well, what would that be? Signing deeds, things of that nature. So you'd initial that, or your personal property, or whatever, insurance, whatever it may be, or you can initial this last one that says, I want them to have all the authority to do that. Oklahoma's works the same way. In Oklahoma, we never had to do that. Now, since 2022, we do. And so it's the very same thing. Before we go to the next section, one very important difference, it doesn't apply to Texas, but it does to Oklahoma. In Oklahoma, there's another section where it requires you to go through, this deals with handling property, things of that nature. In Oklahoma, there's another section where you can designate someone to go in and amend your trust, make gifts, things of that nature, change beneficiary designations and those type of things. And so Oklahoma has a specific provision for that. Texas does not. But in Texas, what we would do is you would address that under Section 5. Let's go to Section 5. Section 5, or go ahead and scroll it up. Section 5 has other special instructions. Now, those type of decisions of whether that power of attorney can change your trust or change beneficiary designations or payable on death on bank accounts is addressed specifically in Oklahoma's. Texas's is not, so you would put that information here. I don't have it in here now. These are some of the standard provisions that you will see, but you always have the ability to add others. So let's kind of look through some of the standard provisions that Texas has in Section 5. The first one deals with compensation. The question is your agent, the person acting under the power of attorney, going to be reimbursed expenses and receive compensation? Here it says they receive reimbursement of expenses and compensation for serving. Here it says they do not receive compensation, but they are reimbursed expenses. You simply will initial the one you like. Let's go scroll up a little bit. The next 502 talks about, this is what I was talking about earlier, about how those co-agents are going to act. In Texas, you have a specific question about it. In Oklahoma, we have to address it specifically in a separate provision in the special instructions. But regardless, it has to be addressed somewhere. So in your Texas power of attorney, 502 says, okay, if I've got co-agents, each one can act independent of the other, or they've got to act jointly together, or it's majority. Now, if you have two, this doesn't exist. There's no majority of two, right? It's either they can act independent or they have to act together. So you specify that, and that's very important. Let's go down to 503, talks about gifts, if you want to grant them to be able to make gifts. What is very specific in both Texas and Oklahoma is you do have to have a specific grant to make gifts. In the Oklahoma power of attorney, there's a specific question about that in a different section. Here in Texas, here's your specific question about that. So in other words, that power of attorney, let's say you're not able to do that, but let's say that you had a pattern of making gifts, maybe at Christmas or whatever it may be, and you want that to continue. Unless that authority is granted, gifts cannot be made. So that's why you have to make that gift. Scroll up just a little bit. 504 talks about, this is just basically administratively, it talks about a copy is good enough. This power of attorney specifically says you revoke any prior power of attorneys. It's a coordinating provision. So what happens if you have a prior power of attorney and now you execute this one? By executing this one, it automatically revokes the prior one. And so, and Oklahoma's works the same way that way. We always put those in there because we want to make sure that they coordinate together so there's no ambiguity as to which one controls. 506. This is a very important provision. We include this. This isn't required by statute either in Oklahoma or Texas, but you guys are familiar with HIPAA. I know surely Medic knows it for sure. You live it every day. But HIPAA is, and here's the actual name of the act, Health Insurance Portability and Accountability Act. It's the law that says no one's going to tell anybody my medical information except for me. Now, tell you a quick story about that. I live in Enid. I had they're a client now, they weren't at the time, but there was a lady that lived in Fairview. Fairview's about 45 miles west of me. She had signed a HIPAA release with her doctor. She had signed one at the local hospital. Problem was, she had a power of attorney. Problem was, that power of attorney did not contain a HIPAA release, but she had signed them with the doctor and hospital. The problem was, she got transported to a specialist in Enid at Bass Hospital. Now, in today's society, I get it. Everybody's concerned about being sued. Technically, legally, she goes in the hospital. She can't sign a HIPAA release. The daughter calls me, introduces herself, and says, hey, I'm having trouble getting the information. Legally, when you appoint an agent to act for you, it's the same as if the person's talking to you. So if I've appointed my spouse, my wife, to act as my power of attorney, it's the same as if you're talking to me. Everybody's concerned about being sued, so they wouldn't release the information. I talked till I was blue in the face. They wouldn't release the information. At the time, this was a number of years ago, I went back to some of my colleagues and said, hey, have you guys seen this? Some had, some hadn't. And what we concluded is if you include the HIPAA release in the power of attorney, it will follow you wherever you go. Because what it's doing, it's releasing that, it's an authorization to release information to that agent regardless what the circumstances are. Most HIPAA releases you see today are specific to the institution having you sign it. So if that lady would have had a power of attorney with the HIPAA release in it, when she came to Bass Hospital and was seeing the specialist, it was already released. That's the purpose of including it. Now, this is a financial power of attorney. So why do we include it here? Well, we include it here, although it's a medical related issue, we include it in the healthcare power of attorney, but we also include it here in case a guardian's appointed. Remember that we talked about earlier that a guardian could be appointed in some circumstances? If that happens, we want that guardian to have full authorization on that behalf as well. So that's why we include it here. But that's why it's a HIPAA release. If you go to 507, there's others. In our forms, we leave some blank lines. If you have a laundry list of additional things you want to do, we just add those, but this is the special instructions. Let's go to section 6, if you'll scroll up. Now, Oklahoma's is a little different, but it's the same concept. In Oklahoma's, regardless which state you're in, you're going to have to tell them whether you want this power of attorney effective immediately or upon your incapacity. Most of the times, what I recommend is in a marital situation, especially if the couple's been married a long time. My wife and I have been married 33 years. It's 33 years for more. Katrisa says it feels more like 50 to her. So, but anyway. So what happens is, in those situations, I usually recommend make it effective immediately because the couple is usually on each other's bank accounts, right? They already have some authorization of some kind. Why is that important? Because if it's effective based upon your incapacity, what triggers that is just not the agent saying, hey, you're incapacitated. They have to go get physicians' opinions to that effect. So if it's a situation like that, I usually recommend make it effective immediately because what that does is it saves the step of having to go get the physician's opinions. But if it's a more remote relationship, let's say my wife is deceased, my kids are not able or can't do it, and I'm appointing maybe a nephew or niece or friend or something. Well, then in that situation, I may want to make it effective based upon my incapacity and get me more comfort in doing that. So you do make that decision as to whether you want it effective immediately or upon your incapacity. And then Section 7 is third-party reliance. In other words, both states have, and this specifically says Texas law, Oklahoma is very similar, that both states have provisions where if a party, bank, financial institution, brokerage, whatever it may be, accepts this power of attorney and relies on it, they're able to do that without any concern of being sued or things like that. We have the signature line for John. We have address. Of course, like I said, we pulled this off for Oklahoma, but this would be Texas, and then the telephone number as well. Now, if you keep scrolling down, one of the changes we've seen, it does have to be notarized. I love, we're about that time of year. I'm a big Peanuts fan. And, you know, each year Lucy sets the football out for Charlie Brown to kick the football. And then, of course, he runs up and tries to kick it, pulls it away, and he falls down, right? And then what's funny about that is she hands him a piece of paper and says, well, here, I won't do it this year because here's a contract, you know? And so he's walking back and he says, oh, it won't happen this year because I have a contract. And so he runs up there. She still pulls the football away. He falls down. She catches the contract. She says, something's interesting about this contract. It's not notarized. Okay? Contracts do not have to be notarized to be effective. But there are some situations that you have to have documents notarized to be effective. This is one of those. The main reason for it is not to just give assurances that you did execute it, but also if it's ever needed in a real estate transaction, in order to file it, not only does it have to be notarized, but you have to have the original. Now, we've encountered that before. What we do in our practice, and some lawyers are all different, but I like to give, once clients execute documents, we will take a picture of those. I like to give those originals back to the client for a couple of reasons. One is a selfish reason. We don't want to house all the paper. Okay, we keep it all electronically. But the other one is for the client. I want the client to feel comfortable. They got their originals back and they can do whatever they want to with their documents. They don't feel tied to the firm. If they want to come back to us, great. If they don't, that's fine too. So what happens is, the reason I'm telling you that is because when you get your original, you need to make sure you keep track of it. Let's say you get down the road, what I've run into is we give originals back to, let's say, parent. Child needs to use it. They get down the road. They need to use it for a real estate transaction. Okay, in order to file it, not only does it have to be notarized, but it has to be the original signature. There's very few things in the law that you have to have the original document. This is one of those. They get down the road and the child can't find the original. Okay, so we can't file it in the real estate records, which means we can't use it for the real estate transactions. So you want to make sure you always have the original. You can sign more than one if you want, depending on whatever you and your lawyer want to do. The law now requires some kind of identification by who has prepared it, and that's here. And then the law, if you'll scroll up, also requires, these are instructions for the agent. Remember when we started, it was instructions to you under Section 1 about how the power of attorney works and those type of things. This is instructions for the agents. Just more or less you got to act in good faith, you got to be loyal, those type of things. Now, I will say one last thing about power of attorneys, specific to this. It's very, very important that you give thought to who you pick as a power of attorney. There's no requirement that there has to be a relationship, meaning that there has to be a relative relationship. But I'll give you an example. I think the best thing to do, legally, you're putting the person in a position to act for you. Legally, they have to do that, just like this document says, right? It says they've got to act in good faith, they've got to be loyal to you and all those type of things. But there's a difference in them legally having to do it and having to enforce that. Had a client in my office a number of years ago. There were 3 kids involved. There were 2 boys and a daughter, and there was the youngest son that was kind of the favored son. I always tell clients, you tell me who you want to appoint. You know your kids better than I do. I don't know them. But when you're doing that, think about their strengths and weaknesses, okay? This favored son that she liked was was her favorite, and she wanted to appoint him. And then she made a comment on the order of, well, I'm pretty sure he can handle this. And I said, what do you mean pretty sure? She goes, well, he hasn't been the best with finances before. And I said, okay, well, let's talk about that. Well, he's going through a foreclosure right now. Okay. Now, there's reason people go through those things. I mean, we understand that. Well, he's filed bankruptcy. Okay. And there was another criminal charge for some kind of embezzlement. I said, ma'am, do you think he's the best choice? I know, and you may not be my client at the end of this conversation. I understand that. But my job is to be honest with you, and as a third party, I don't think he's your best choice. Think about who you're appointing. And I will say this too. What's unique, this is my 30th year of practicing law. Out of 10 families that come in my office, maybe one is the Leave It to Beaver family. Every family has issues. Different types, but different issues. Very seldom, 10% would be 1 out of 10. About 10% of the people who come to my office, those families are ones that don't have any type of real issues that they're facing. Everybody has some type of issues. So many times clients are apologetic about that, and I tell them, don't be, we're all there. My family's been the same way. But that's the power of attorney, and that's how it works. As you can see, it's a pretty straightforward document, and it saves that process. I can't tell you how burdensome guardianships can be. The thing that makes them burdensome too is that they have to stay in existence the entire time the person's living. And we're talking thousands and thousands of dollars. You're going to have in a guardianship, you're going to have a court hearing at least once a year on their annual renewal. So I've always been a proponent during my 30-year career of power of attorneys, simply because trying to follow the principle of let's try to do the simplest first to fix the problem. Now, if that doesn't work and there's another problem that requires a guardianship, okay, then we'll get more complicated. But 9 times out of 10, this takes care of it, and it's a lot easier, and we don't have to go through all that process.